A federal appeals court has now ordered a sitting United States district judge to shut down a criminal contempt case against the Trump administration. And it has done it twice in the same year. That is not a talking point from either side. That is the actual dated ruling sitting in the federal court record right now. I went through all four major rulings in this fight, the panel opinions, the dissents, and the sworn declarations behind them, more than 200 pages combined, so you would not have to. By the end of this video, you will know exactly why a federal judge found probable cause for contempt in the first place, why two appellate judges shut him down not once but twice, why one dissenting judge just spent close to 80 pages warning that this decision could weaken every court in the country, and exactly where this fight stands today, because it is still not finished. Here is where it starts. On March 15, 2025, President Trump invoked the Alien Enemies Act, a wartime law from 1798 to deport men the administration accused of belonging to the Venezuelan gang Tren de Aragua. A lawsuit was filed that same day in front of U.S. District Judge James Boasberg, the chief judge of the federal trial court in Washington, D.C. Boasberg held an emergency hearing and ordered from the bench that any flights already in the air be turned around. More than 200 men were flown to El Salvador anyway, straight into a maximum security prison known as CCOT. That single day, that single order, and what happened after it is the entire spine of the story you are about to hear. A quick note on that law, because it matters for everything that follows. The Alien Enemies Act dates back to 1798, and historians who track its use say it had only been invoked 3 times before this, during the War of 1812, World War I, and World War II, when it was used as part of the legal basis for interning Japanese, German, and Italian nationals, using it against an alleged criminal gang rather than during a declared war against a nation-state, was itself legally untested, which is part of why the case moved so fast through the courts. There is also a human side to this that a lot of coverage skipped past. A CBS News investigation using 60 minutes of reporting examined a list of men sent to CCOT and found that roughly 75% had no apparent criminal record at all in the United States or anywhere else. About 22% had some criminal history, mostly for nonviolent offenses like theft, shoplifting, or trespassing. Around a dozen were accused of serious violent crimes, including murder, assault, and kidnapping. Those men spent months inside CCOT, a maximum security Salvadoran prison built for gang members, before being released this past summer as part of a prisoner exchange between the United States and Venezuela. Whatever you conclude about the legal fight, that detail is not spin. It is a documented fact about who was actually on those planes. Boasberg did not let it go. On April 16, 2025, he issued a 46-page ruling. In it, he wrote that the government's actions on that day demonstrate a willful disregard for its order. He found probable cause to hold the administration in criminal contempt, one of the most serious tools a federal judge has, and one almost never used against a sitting president's own administration. He gave the government 1 week to fix it by giving the deported men a chance to challenge their removal. He also wrote that the Constitution does not tolerate willful disobedience of judicial orders. That is a federal judge appointed by President Obama in 2011, putting in writing that he believed the executive branch had defied him on purpose. The administration's response came fast. The Department of Justice said in a statement that Judge Boasberg has no right to seize control of the president's authority to conduct foreign policy, pointing to a Supreme Court ruling from 9 days earlier on April 7th, 2025, that had vacated Boasberg's original order on jurisdictional grounds. That Supreme Court ruling is important and often gets skipped over. The justices did not say the deportations were legal. They said Boasberg's order had been filed in the wrong venue and that the men still had a right to challenge their removal through the courts before being sent anywhere. The administration read that as vindication. Boasberg read it as beside the point, because his contempt finding was not about whether the underlying policy was legal. It was about whether his order, right or wrong, had been obeyed while it was still in effect. Boasberg himself is not a newcomer to high-profile cases. He has served on the federal bench in Washington since 2011, was appointed by President Obama, and became chief judge of the district in 2023. He has handled major national security and public records disputes long before this case, which is part of why both sides in this fight treated his rulings as carrying real institutional weight, rather than dismissing them as the work of an inexperienced or obscure judge. That distinction is the entire fight, so sit with it for a second. Civil and criminal contempt are not about whether a judge was correct. They are about whether the government gets to unilaterally decide a court order does not apply to it. If that sounds abstract, here is the plain English version. Imagine a referee makes a call you think is wrong. You do not get to just keep playing as if the whistle never blew. You appeal, you argue, you get the call reviewed. What you cannot do under the rule of law, as it has worked for over 2 centuries, is simply ignore the whistle because you are confident you will win the appeal later. That is the accusation Boasberg leveled at the administration, and it is why this case pulled in constitutional law professors, 4 separate Court of Appeals rulings, and eventually a rare public comment from the Chief Justice of the United States. Before we get to how the appeals courts responded, there is a piece of this story that almost nobody outside legal circles has heard, and it involves a Justice Department whistleblower. His name is Erez Ruveni, a former DOJ attorney who was fired after the deportation flights controversy. Ruveni released internal documents and text messages showing that another Justice Department attorney, Drew Ensign, had told Boasberg in court that he was unaware whether flights would take off in the next 24 to 48 hours. Ruveni's own texts, shared with a colleague at the time, suggested Ensign already knew the flights were happening. If true, that is not a disagreement about legal interpretation. That is a government lawyer telling a federal judge something the lawyer's own colleague believed was not accurate in real time, while the judge was actively deciding whether to ground those planes. Ruveni's story did not end with a press release. He was fired from the Justice Department shortly after coming forward, and he later filed a formal whistleblower complaint laying out his account of what he says he witnessed inside the department in the days around the flights. Whistleblower complaints from career DOJ attorneys are rare on their own. One tied directly to a sitting federal judge's contempt investigation, arriving in the middle of active litigation, is rarer still, and it is a major reason this case pulled in national attention beyond the immigration policy debate itself. Then there is Kristi Noem, who was Secretary of Homeland Security at the time. The administration has said it was Noem who made the call in March 2025 to send the flights forward despite Boasberg's order. In a written declaration to the court, Noem said she acted on what she called privileged legal advice from the department's counsel, and through him, from senior Justice Department leadership. Boasberg was not satisfied. He called her declaration cursory and pushed for more testimony, more documents, and eventually ordered Ensign himself to testify under oath about what happened that day. That is roughly a year of fact-finding hearings and testimony, all aimed at one question. Did senior officials in the Trump administration knowingly defy a federal judge's order? Boasberg believed the evidence pointed toward yes. And this is where the story turns, because Boasberg was never actually allowed to finish that investigation. Not once, not twice. The D.C. Circuit Court of Appeals stepped in and stopped him at nearly every turn. The first stop came fast. On April 19, 2025, just 3 days after Boasberg's contempt ruling, a motions panel of the D.C. Circuit made up of Judges Gregory Katsas and Naomi Rao, both appointed by President Trump in his first term, issued an emergency administrative stay freezing the entire contempt proceeding. Judge Cornelia Pillard, an Obama appointee on that same panel, disagreed, writing that without a clear right to relief, there was no ground for a stay at all. That 2 against 1 split on a 3-judge panel along strict appointment lines becomes the pattern for the rest of this saga. By August 8, 2025, the same 2-judge majority, Katsas and Rao, went further, formally vacating Boasberg's contempt finding entirely, citing the Supreme Court's earlier decision on jurisdiction. Pillard dissented again, writing that a system of courts cannot survive if litigants get to defy orders with impunity rather than challenge them through the proper legal channels. The ACLU's lead attorney on the case, Lee Gellernt, said the organization strongly disagreed with the decision and was weighing its next move. It is worth pausing on how unusual that November decision actually was. And bank review, where the full bench of active circuit judges takes over a case instead of leaving it to a random 3-judge panel, is rare. Circuit courts grant it only a small fraction of the time it is requested because it is meant for cases involving exceptionally important legal questions or direct conflicts between panels. The fact that the full D.C. Circuit agreed to step in, reverse course, and hand the investigation back to Boasberg, only to have a new 3-judge panel shut it down again 5 months later, tells you how genuinely divided the judges on that court were about where the legal line actually sits. Most people watching this case assumed that was the end of it. It was not. In November 2025, the full D.C. Circuit, sitting as what is called an en banc court, meaning all the active judges on the circuit rather than just a 3-judge panel, actually gave Boasberg the green light to restart his investigation. For a few months, the contempt inquiry that had twice been frozen was alive again. Boasberg used that window to order Ensign's sworn testimony and to keep building the factual record. While that window was open, legal scholars outside the case were already warning about the deeper structural problem underneath it. Erwin Chemerinsky, the dean of Berkeley Law School, wrote around this same period that the Constitution gives judges no direct power to compel compliance with their own rulings, and that enforcement ultimately rests with the executive branch itself. That is not a partisan talking point. It is a basic and uncomfortable feature of how the American government is built. Courts can rule. They generally cannot personally force compliance. They rely on the same executive branch they may be ruling against to carry out the order through agencies like the U.S. Marshals Service. When that same executive branch is the one accused of ignoring the order, the system does not have a clean, built-in answer for what happens next. And that gap is exactly what this entire case has been fighting over for more than a year. Here is your callback to what I promised you at the start of this video. I told you 2 appellate judges shut this case down not once but twice, and that a dissenting judge just wrote nearly 80 pages warning about the consequences. This is where the second shutdown happens, and it is the bigger one. On April 14, 2026, a new 3-judge panel of the D.C. Circuit ruled again, this time made up of Judge Rao, Judge Justin Walker, also a Trump appointee, and Judge J. Michelle Childs, appointed by President Biden. In a 2-to-1 decision spanning 122 pages, Rao and Walker granted the administration what the court itself called extraordinary relief, a writ of mandamus, ordering Boasberg to permanently terminate the contempt inquiry. A writ of mandamus is worth explaining in plain English because it is not a term you hear every day. It is an extraordinary order from a higher court telling a lower court or a government official to stop doing something they are not legally allowed to do. Courts do not grant it lightly. It is meant for situations where a lower court has clearly and indisputably overstepped its authority, not for ordinary disagreements about how a case should proceed. The fact that the D.C. Circuit reached for that specific rarely used tool rather than simply letting the normal appeals process play out is itself part of why Judge Childs' dissent treats this ruling as such a significant departure. Their reasoning was specific and worth understanding in plain terms. Boasberg's original spoken order at the March 15 hearing told the government to turn the planes around. But the written order he issued less than an hour later, the one that legally controls once it is filed, only barred removing people who were still in the United States. Judge Walker, in a separate concurring opinion, wrote that the government did not violate the oral order while it was in effect, and at no point violated the written order that replaced it. Rao put it directly in the majority opinion, writing that the TRO, meaning the temporary restraining order, did not clearly and specifically bar the government from transferring the men into Salvadoran custody. Her conclusion was that Boasberg's continued investigation into senior executive branch officials was a clear abuse of discretion. Now, here is the dissent I promised you. Judge Childs did not go quietly. She wrote a dissent stretching close to 80 pages, and inside it is one of the most direct warnings about judicial power you will read from a sitting federal appellate judge. She wrote that contempt of court is a public offense, and the fate of our democratic republic depends on how seriously courts are allowed to treat it. Her broader argument was structural. If an appeals court can step in this early, before a contempt finding is even made, and declare that officials could not possibly have violated an order because the order was supposedly unclear, then any future litigant facing any future contempt charge can make the same argument and short-circuit the process before the facts are even fully gathered. She was not just defending Boasberg. She was arguing that the majority's ruling changes how contempt works for every court in every case going forward, regardless of who is in the White House. Acting Attorney General Todd Blanche responded almost immediately, posting that the ruling should finally end what he called Judge Boasberg's year-long campaign against Justice Department attorneys. Lee Gellert of the ACLU called the decision a blow to the rule of law. Both of those reactions are real, on the record, and from named officials, and both of them are also, obviously, advocacy. That is worth sitting with for a moment, because this is not a story where one side is simply right and the other is simply wrong. It is a genuine, unresolved argument about where the line sits between a court's power to enforce its own orders and a court's power to reach into how the executive branch runs national security operations. So why does this particular case matter more than a routine contempt dispute? And there are routine contempt disputes against presidents. Bill Clinton was held in civil contempt in 1999 for misleading testimony in a deposition. Donald Trump himself was held in civil contempt by a New York state judge in 2022 over document production in a fraud investigation and paid a $10,000 a day fine until he complied. Those cases were serious, but they were contained. A single judge made a finding, a single set of fines applied, and the matter resolved within the same court system without triggering a year-long fight across multiple levels of the federal appellate bench. There is an even older comparison worth knowing. Presidents have clashed with federal courts over enforcement before, going back generations. And legal historians often point out that the tension between judicial rulings and executive cooperation is not new to the American government at all. What has changed in this case is the scale and the speed. 4 separate appellate rulings, a Supreme Court decision, a whistleblower complaint, and an 80-page dissent, all inside about 13 months over a single set of flights that took off on a single day. That pace and that volume of litigation over one contested order is unusual, even by the standards of high-profile presidential legal fights. This case is different because it never got that far, and that is exactly the point of Childs's warning. The fight here is not over whether the administration actually defied the order. It is over whether Boasberg or any trial judge is even allowed to finish investigating that question before an appeals court can step in and end the inquiry on procedural grounds. That is a fight about the machinery of the courts themselves, not about the underlying deportation policy, which is why constitutional law professors keep describing it correctly as one of the more significant separation of powers cases of this era. There is one more real documented piece that shows just how unusual this fight became. President Trump publicly called for Boasberg to be impeached over his handling of the case. Chief Justice John Roberts, who almost never comments on individual disputes, issued a rare public statement rejecting the idea that impeachment is an appropriate response to disagreeing with a judge's ruling. For a sitting Chief Justice to step outside his normal silence and push back on calls to remove a lower court judge, that alone tells you how far outside the ordinary this case had already traveled months before the second DC. Circuit ruling even landed. The story is still not closed. In the weeks after the April 2026 ruling, the plaintiffs and the ACLU filed a motion asking the full DC Circuit to rehear the case en banc, the same procedure that had briefly revived Boasberg's inquiry back in November 2025. Their filing argued that the panel's ruling let senior officials off the hook for what the plaintiffs describe as a brazen violation of a court order, one that led to months of documented mistreatment for the men held at CCOT. The Trump administration's response, filed in opposition, argued flatly that the government did not violate any court order at any point and said that reopening the case would only raise the temperature without changing the outcome. Whether the full circuit agrees to take the case up again is still pending as of this recording. There is also a newer thread developing alongside the rehearing fight. Legal commentators tracking the case have raised questions about the conduct of senior Justice Department leadership during the original March 2025 episode, separate from the contempt ruling itself, and that piece of the story is still unfolding in real time as more filings become public. If the full DC Circuit does take the case back up, or if it eventually reaches the Supreme Court again, it would be on a different legal question than the one the justices already resolved back in April 2025. That earlier ruling was about jurisdiction and due process. This next round, if it happens, would be about something more fundamental, whether a trial court can even finish investigating a contempt allegation once an appeals court decides to step in early. Here is what this all means if you strip away the politics on both sides. There are more than 200 men who spent months in a foreign prison after a federal judge ordered their flights turned around. There is a sitting federal judge who believed, based on sworn testimony and internal documents, that senior officials knowingly ignored him. There is a federal appeals court that has now twice concluded on legal and procedural grounds that the investigation itself went too far before it ever reached a final verdict. And there is a dissenting judge who has put on the record in writing an 80-page argument that the tools courts use to enforce their own authority are now weaker than they were a year ago. None of those four things cancel each other out. They are all true at the same time. And that is what makes this a genuinely hard case rather than a simple one. If you have made it this far, you now know more about this case than the vast majority of people talking about it online, because you have the actual dates, the actual names, and the actual rulings, not just the headlines. Judge Boasberg is still the chief judge of the federal trial court in Washington. Judge Childs' dissent is still sitting in the Federal Reporter for any future court to read and cite. And the question she raised, whether a court can still hold anyone accountable for ignoring its orders once an appeals court steps in early enough has not actually been answered yet. It has only been postponed. That is the real story behind the headlines you have probably scrolled past over the last year. Not a single dramatic arrest, not a marshal showing up at a courthouse door, but something slower and in many ways more consequential. A grinding document-by-document fight over whether federal courts can still make the executive branch answer for its own conduct. It has been fought out over 4 appellate rulings, 200 pages of dissent, a Supreme Court decision on jurisdiction, and 1 fired whistleblower's text messages that may end up mattering more to the future of this case than anyone expected back in March of 2025. No matter which side of this you find yourself agreeing with, the underlying question is not going away, and it will outlast this particular administration. It is the same question Judge Childs put at the center of her dissent. Can a court still hold anyone accountable for ignoring its orders, or does an early enough appeal make that question disappear before it is ever answered? Right now, in this case, the answer is still open. If you want to see how the next chapter plays out, whether the full D.C. Circuit takes this case back up, and whether it reaches the Supreme Court a second time, subscribe, and I will bring you the next ruling the moment it is filed.